See, 338-469, Hammer.
All right. Sorry for the delay, guys.
That's okay.
No problem. I remember when I was a brand new place to
This is on for the defendant's motion. It's not defendant's motion to revoke bail. It's the state's motion to revoke bail, right? Calendar has it as defendant's motion, but that's not right. Looks like we have a Petrocelli hearing coming up on December 17th. Is that still good for everybody?
It is, Your Honor. For the record, Michael Castillo, 11531, and my colleague Sophie Salcedo.
Bar number 15316, Your Honor. Thank
Good
you.
morning.
Your Honor,
Go ahead.
oh, did you want me to just argue the motion?
Yeah, go ahead.
Okay, thank you. Alissa Engler for the state, by the way. Judge, I filed this motion, as this court is well aware, we did an evidentiary hearing last year regarding, the state's request to revoke the defendant's bail based on contact. After that hearing, the motion was denied, but the court did issue a minute order admonishing the defendant. And I highlighted the portion of the minute order that I believe was relevant to this situation. It said that the court admonishes Julie Hammer that if in the future she contacts or communicates with the minor, either in person or by electronic means, or through another person, including grandma, this court will consider it to be a violation of the no contact order, and the court will take appropriate action. I'm asking the court to take appropriate action, and I'm asking for the bail to be revoked. What I've included in my motion are conversations of text messages through a social media app called Snapchat. I don't know if this court is aware of Snapchat, but it has a function that allows you to communicate similar to a text message. The unique thing about the app is that generally the conversations are deleted automatically after 24 hours. That's why it's called a Snapchat. You can send a photo and then it disappears. It's a creative way for the defendant to kind of get around the normal conversations through phone because the conversations are deleted. In this particular case, we were able to ascertain conversations that happened in September and October between the defendant and the minor child. I have spoken with Laura Dieter, who is the attorney for the minor child, and she informed me that she has spoken to the minor child since we filed this motion, and the minor child admitted to speaking to her mother, to grandmother, to aunt, and cousin over the last several months. As I stated in my motion, the individual that is a part of the conversations, Rosanna Davidson, is the defendant. And I know this to be the defendant because if you read the context of the messages, there's absolutely no question that it's the defendant. There are conversations regarding her fight for the defendant. When you look at the conversations in there, she uses abbreviations when referring to different people, like LD, that would be Laura Dieter. She refers to the minor child's other mother in this case as M, which is Mary or Murphy. She also calls her inappropriate names. That is to be true throughout the messages. Additionally, the conversations that she's talking about in here talks about her fight for her. She references the July trial setting, that this court is aware we have trial in July, informing the minor child that it is in her hands and that she can walk away with the defendant at the conclusion of the trial in July, which is absolutely not true. As this court's well aware, our job here is to determine the innocence or guilt of the defendant's criminal conduct. The outcome of this trial has no bearing on the family court. When I say that the conversations are concerning, it's probably an understatement because this poor child has had to endure the mental trauma from the defendant for years. And you can see it outlined through these messages. She's basically playing mind games with the child. And when the child just wants to talk about other things, she only wants to talk about the court. But she shouldn't even be talking to her in the first place, which is why we're here. I cannot fathom a single thing that this court can do other than putting the defendant in custody that would stop her from contacting the minor child. She has absolutely no respect for court orders, which is why we're here in the first place. This is here for violations of custodial orders, of a detention and concealment and a kidnapping, because she disregarded the orders out of family court. Then we came before Your Honor for violations of no contact order, and this court said, in an admonishment, if you do it again, I will take appropriate action. Well, she's done it again. She is smart. I will give her that. She is smart. She will find a way. She will find a way to continue to contact the minor child. And it needs to stop. And the only way to do that is to revoke her bail.
Thank you. Counsel?
Thank you very much, Your Honor. And with respect to my counterpart with the state, who I've known for many years, as long as I've been practicing on both sides of the aisle, in just looking at their pleadings, I don't think we even get to the point where we even talk about the violation, because the statutes that they cite are inapplicable and they're not on point. And I do lay that out in my opposition at page 3. They start out by citing NRS 178488 that talks about a right to bail on appeal. They then go on to talk about NRS 178499, which is with regard to a motion to increase bail for good cause shown. But if that's the theory they're going by, at least in the written pleadings, there's no required affidavit pursuant to EDCR 3.20.
Judge, I'm sorry to interrupt, counsel. I didn't receive the opposition. When was that filed?
Opposition was electronically filed on November 9th at 5:12.
I got it.
And in relying on my staff, I do
It's an
show
policy.
I do show a certificate of service.
I wasn't on usually I receive all e-filings and I didn't receive it, but.
I am showing a certificate of service, Your Honor, but of course I do rely on my paralegal and staff for the filing.
I'll go back and check my emails, but I
There is
usually.
a certificate of service. Electronic and facsimile submission, transmission on November 9th. So. Go ahead.
Go ahead.
Thank you, Your Honor. So they don't cite the right statute. They essentially start out, in writing, talking about a motion to increase bail. They don't include the required affidavit. They then go on to talk about revocation of bail. But as this court's well aware, revocation is covered by NRS 178487, which talks about if there's a proof, evidence, or presumption grade that there's a felony or new charge committed. We don't have that. So the remedy here is for the court to summarily deny the motion because they cite the incorrect statutes and don't do the proper affidavit. If the court feels that there is that this motion should be heard, then the only on-point statute is NRS 178-484 subsection 12, and that does not call for complete revocation. That calls if the court comes to a conclusion that a violation has occurred, then the court can go to contempt, which is either a $500 fine or, contempt not to exceed, 25 days. But I don't think we even get there to the point where we even need to go into the factual basis or the alleged factual basis, due to the procedural defects in the state's primary pleadings. Assuming argument of the court does want to go into it further, however, I would note that I think it's clear the state provided insufficient evidence to establish that she violated any no contact order. And I think what the state said today was somewhat telling. Laura Dieter says this, or LH the minor child says this. We don't have an affidavit from Laura Dieter. We don't have any statements. Instead, all we have is the state's basically saying, because I say so, take my word for it. It has to be her. It's clear by the text of the conversation. That's the proof the state is bringing here today. That's not proof, Your Honor. That doesn't survive an evidentiary hearing. That doesn't survive a motion hearing. That certainly doesn't get us to a standard by jury trial. If we ever get to that point, all the state is essentially saying through bare bones allegation, well, It must have been Miss Hammer. And because I say it must have been Miss Hammer, it's time to revoke it today. Due process requires much more than that. They have not met their burden of proof, and we're asking the court to summarily deny the motion.
Judge, if I may respond, I did look back through my email. I did not get e-service, and yesterday was a holiday, and our office, we're not in the office, so, in the future, if they could email me directly motion, or oppositions, I would have responded.
I'm happy to do that.
With respect to the arguments, Judge, when you look through the messages, there's pictures of the defendant's other son in the photographs. It's her sending pictures of the minor child's brother to her. There's text messages in here regarding what's happening at home, what's happening at court, what she's doing. If you look at this and you say this is not the defendant or it's not the defendant's family communicating with her, then I just think you're wrong. But if we need to bring a minor child in here to testify, which I don't want to have to do, but I will if this court requires it, and she'll tell you because she'll be put under oath. If that's what they want, that's what I'll request. But I don't think it's necessary. This court said it would take appropriate action if it found out that the defendant violated the terms of its order. I have put that before this court. I have provided conversations and I can provide testimonial evidence if required.
I feel very bad for this little girl that's being dragged through this. I don't think it's fair, Ms. Hammer or for Murphy to be doing this to this poor little girl. Here's the problem that I guess I have. I think it's fairly clear from what I see in the messages that it's the defendant, Ms. Hammer, doing this. But I can't say for sure. And because we don't have some kind of chain of custody, we don't have some kind of documentation from the cell phone carrier or anything like that documenting that it's her. I understand we have the investigator report, but I don't know that that's sufficient that I can find that it was Miss Hammer as opposed to grandma or somebody else. Because of that, I don't feel comfortable finding contempt at this point. I don't think that the statutes will allow me to revoke bail for this violation. I think defense counsel is right. I mean, if there is a violation, it's a contempt violation. Here's what I'm going to suggest. I'm going to impose an additional condition on the out of custody status at this point, and say, Ms. Hammer, that you are not to have any possession, custody, or control of any electronic devices that are capable of sending or receiving messages to the minor daughter, the girl. I'm anticipating, because I think that this was you that sent these messages, that you're going to probably violate that. If that happens and the state provides me evidence sufficient to establish that you violated that, I will probably impose 25 days jail every time that there's a violation. I'm just telling you now, because we need to get through this case and get to the end of the case without having to keep coming in for violations over and over. And if there are continued violations, I'll just find that there's a contempt each time and have to do that jail time. I would prefer not to do that. So that's why I'm just kind of giving you the warning now, so that everybody knows in advance that will come. If the state has this again, I think there needs to be some type of additional documentary evidence that it's her as opposed to grandma or somebody else.
Well, and Judge, I'm happy, I told you this court.
I don't want to bring the girl in here to testify.
But if that's what this court's requiring for me to be able to prove it, it's coming directly from the minor child. There's more than just the text messages. There would be phone conversations through this app. I can bring her in here. The court can interview her in chambers where she's not in front of everybody if that's what this court requires. I don't want to have to do that. I'm trying to protect her. as much as possible. The defendant doesn't care. She acts like she does, but she doesn't, because she continually violates the orders. So if I have to bring her in here, I will, but I don't want to do that.
Well,
And the court's basically saying, I'm not proving my case because I'm not bringing in this 14-year-old girl to testify.
I hope that there'd be other ways that you could establish it, that it was her, but
It's a social media app, Judge. It doesn't work the way that cell phone technology would work.
I'm going to deny it for today. But we're going to pose that additional restriction, and we'll see what happens. We're going to try to keep this from happening in the future. If it does,
And Judge,
bring
just
it
to
back.
be clear, because your prior order said no contact from the defendant or defendant's family, does that mean if I have proof that the defendant's family is contacting her, that I can bring that as a violation through the defendant? Because that's exactly what's going to happen. I know what's going to happen. She's going to walk out of here, and they're going to find a way to communicate with her. That's what they do.
And now we're just doing unfounded, speculation at this point, Your Honor.
It's not like I can find grandma in contempt because she's not a party to the case. So
But what's going to happen is the defendant's not going to have any access to it, but she's sitting right here, and she's going to find a way to communicate with her. They'll do it. They've been doing it for 1.5 years, for 2 years. That's what's going to happen. And I'm going to have to waste this court's time again and file motions and do evidentiary hearings for the same thing. It's going to happen.
if it happens again, as opposed to bringing the girl in here, maybe you can get an affidavit or some type of declaration from her.
Okay, that I would be happy to do. And so the defendant is to have no phone, no computer, no tablets, nothing with access to internet or phone?
I was going to seek clarification on that, Your Honor, just in terms of, we understand clearly the no contact with a minor child. That's been made crystal clear by the court. But just in terms of, can she email counsel? Like, what's my clarification on that?
At this point, I don't want her to have any possession, control, or custody of any device that will allow her to communicate with this girl. If that means that she can't carry a cell phone or a tablet or anything else, that's what it means. She's going to have to communicate with you with pay phones or some other method.
I guess the issue, though, Your Honor currently has her on house arrest, and the terms of house arrest require her to have a phone. So would she be required to get the basic phone? Is that essentially what the court is saying?
Get a flip phone or something that doesn't have internet access.
Okay.
Yeah, I don't want to keep putting limitations, but it seems like I have to keep doing something. I could put her in jail for 25 days today, but I don't know that we're to that point yet. So let's see if we can avoid the jail time. We'll see. I keep trying.
Yes, Your Honor.
Okay.
Good luck.